So I'm going to start, Juliet, if I may, with the view from the SRA. Obviously, there's long experience of compliance or otherwise with money laundering and now the broader terrain of economic crime. What's the SRA's take on that?
Thanks, Stephen. Yes, well, I mean, it's called The View from the Regulators. So I was going to talk about about economic crime because it really is taking up a lot of the horizon from where we're sitting. And, you know, we know from the latest National Crime Agency assessment that serious and organised crime in the UK continues to grow. Geopolitical instability, the cost of living crisis, these have all provided opportunities for organised crime groups to exploit the vulnerabilities of people and systems. And developments in the use of technology, which in the legal sector deliver many opportunities to improve access to justice and, you know, choice and quality in services for consumers, but also on the flip side remain a key enabler for risks around cybercrime, AI-enabled fraud and the like. So it is a key area of focus for for legal regulation and for government and legislators. The invasion of Ukraine has in particular driven new work for us in the last year, 18 months. We've been involved in screening client lists of high-risk firms with exposure to the Russian market to look at compliance with financial sanctions. We've been calling in information across all the firms we regulate and carrying out inspections and reviews of firms' approach to financial sanctions compliance. And that's led to us publishing some guidance to help firms navigate the regime with red flag indicators, expectations for what a good control environment looks like. We've also got the Economic Crime and Transparency Act. It's due to go to its final reading next week, I understand, and that's going to bring in a new regulatory objective, which is going to govern our work and be overseen by the Legal Services Board, of promoting the prevention and detection of economic crime. And it's going to introduce measures, including a new statutory definition, early dismissal mechanisms as well for SLAPS litigation relating to economic crime, as well as new powers for us to carry out proactive inspections and to impose higher fines in relation to economic crime offences. And we've also got Treasury looking at strengthening anti-money laundering supervision in a consultation on new models for the regulatory architecture, looking at the roles and responsibilities of the professional bodies and other bodies involved in that. So, preventing economic crime, financial sanctions, money laundering should be a priority for the legal profession. But we are seeing that firms are still not getting the basics of identifying and managing money laundering risks right. We're going to be publishing our annual report next week, summarising our activity in this area. And that's going to show that firms have made little progress, a little improvement in some key areas of compliance. And I want to just touch on assessing risk, if I may. Firstly, at firm level, a firm-wide risk assessment is the backbone of a firm's AML controls. It forms the basis of its policies, controls and procedures and feeds directly into the assessment of risks presented by individual clients and matters. Decisions, for example, about levels of due diligence that need to be undertaken, ongoing monitoring, critically whether to accept instructions in the first place. We've published guidance, we published a checklist, a warning notice and a template firm-wide risk assessment, and those have all been in place since 2019. But although most firms now have a firm-wide risk assessment in place, just under half of the firm-wide risk assessments we reviewed over the past year were fully compliant. And there are still a number that missed out entirely on one of the 5 key risk factors that are required under the regulations, or use boilerplate text that just wasn't tailored to the firm and in its work at all. And when it comes to client and matter risk assessments, we've continued to see low levels of compliance since this was first raised as an issue in our 2019-2020 report. At that time, we found 29% of files had no written matter risk assessment. And in this reporting period, we found that on 1,245 files, that's looking at 224 firms, 21% didn't include both a client and a matter risk assessment. And of the assessments that we looked at, 27% didn't reflect the firm-wide risk assessment, 43% didn't show when enhanced due diligence was necessary, and 51% were ineffective in other ways. So they didn't have a risk rating included, or the risk scoring was really unclear, or the form assessed business or commercial risks, not anti-money laundering risks, so it wasn't really used for the right purpose. So as a result of our concerns, we've carried out a thematic review. Next week, we're going to be publishing the results of that, and that's going to highlight some areas of good practice and poor practice. And at the same time, we're going to be publishing a warning notice highlighting areas to watch for, as well as a suite of further resources, such as templates and best practice examples and tools like that. But I think I'd end just by saying, stepping away from the detail, the main message I wanted to emphasise was that, firstly, money laundering is not a victimless crime. Lawyers can play a really important role in preventing it. Failing to do so risks not only the reputation of the business, but also public confidence in the integrity of the profession as a whole. And really, compliance is about culture, and culture is about leadership values and people. And what we see in good firms is that they're really alert to the risks of doing business. This is part of a daily conversation between fee earners and others in a firm. The reasons for the requirements are understood. They're not seen as a tick box. They're not just seen as the responsibility of a centralised compliance team. This culture is really created through tone from the top and through good, frequent training and discussions on these kind of ethical issues and obligations. And importantly, that reinforces that wider understanding that the risks of the public interest, that these kinds of requirements that are at heart of these kinds of concerns should be front of mind. And where there is a conflict, that these should take precedence over the interests of any particular client or any particular transaction.
Thanks, Juliet. There's some really important messages and practical implications in there that I think, given the response to the question, which actually was totally made up of either inadvertent or reckless about the behaviour, then there's clearly something to be done to raise the consciousness, as it were, within law firms. So thank you for that, and two important reports to look forward to next week. Mark, from the bar's point of view, obviously we've looked at the view of the solicitors regulator. From the bar's point of view, you recently looked at sanctions and commercial chambers.
Yeah.
What sort of messages emerge from that?
Well, it's interesting, Stephen, that your kind of opening question honed in on city law firms. And that does, to some extent, underline that the risks differ between the legal professions. I mean, I very much agree with Juliet's emphasis on anti-money laundering and combating economic crime. But how that manifests itself at the bar is a bit different. For a start, the bar continues to be primarily a referral profession, so most clients are getting to barristers through solicitors rather than directly. And barristers are neither handling client money nor concluding transactions on behalf of their clients. So they are primarily representing clients in court, which is very visible, clearly, or they're advising them behind the scenes. And I guess the risks are more in the latter area than the former. Against that background, we did do some extensive work with commercial chambers in the last year to understand the approach that those chambers are taking. And if you're interested, you'll find the published report on our website. I think from our point of view as the regulator, the interesting findings are about the inconsistency of approach between chambers, in some cases leaving it largely to individual barristers to undertake due diligence on new clients. In other cases, much better cases, establishing at the Chamber's level some policies for due diligence and for undertaking anti-money laundering checks. And in some cases, the Chamber's undertaking some of that work on behalf of their tenants. And from our perspective, we want to see Chambers being much more active in establishing frameworks of policy within which they are expecting their tenants to operate. And indeed, that's part of a broader approach and initiative that we're taking as the regulator to clarify our expectations of Chambers, not just in the area of economic crime and anti-money laundering, but more generally in relation to standards, to equality, and to access for consumers. So you can expect to see us as the regulator, being clearer with Chambers, what can we expect in this field.
Excellent, thank you. If I can turn to you, Matthew, as the oversight regulator, we've got issues here which clearly are around compliance with statute and regulatory obligations, but there seems to be a broader emerging theme in the political world and in all forms of media about much broader ethical considerations. So, might be all right for you lawyers to say, oh, what we've done is lawful, but civil society says, yes, but what you've done is awful. And is that a concern to the board as an oversight regulator?
It certainly is a concern, and as you know, we've got a major piece of work looking at professional ethics and the rule of law. But if you'll permit me, I've got some remarks prepared, but I'm going to deviate slightly to make an uncharacteristically provocative remark. Listening to Mark, loads of good stuff, and really applaud what the Bar Standards Board is doing. But I hear the argument that barristers are different because it's largely a referral profession all the time. And, the fact that most clients come to barristers through solicitors, I've always seen as a very strong argument in favour of merging the Bar Standards Board with the Solicitors Regulation Authority. So I'll just leave that one hanging for today and return to my first course. This is something of a first for me. It's not my first attendance here, and I do lots of talks on legal regulation, as you would expect. But it's the first time I felt able to commence my remarks by quoting heavily from the president of the Law Society. And just to make sure that I'm getting it right, I have written it down here. So Lubna Shuja, who I think has been an excellent president of the Law Society in the last year, made some remarks on the topic of professional ethics and compliance recently, which really struck a chord with me. And what Lubna said was, and this ties in with something Juliet said at the end of her remarks, leadership is key. We must see personal behaviours and virtues, Lubna said, across the profession, including at the senior levels, which create an environment that supports rather than prevents or suppresses ethical behaviour. But Lubna went on, and referring to the SRA's Code of Conduct, these principles do not only come into play when there are issues of whether the borders of legality may have been crossed, your point, Stephen, about lawful but awful. Ethical dilemmas often arise within the realm of what is legal, but might not be considered as acceptable by some. And Lubna concluded by saying, this leaves us to figure out what defines the public interest, a relative term that can be subjective, depends on context, and could be time and culture specific. And as I said to Lubna, I could not have put it better myself. Really well made points. And it's very welcome to hear the Law Society, as one of the foremost leadership bodies in the space, speaking in such clear and powerful terms. And I think it's this question of what constitutes the public interest in the legal services sector that we'd like to see everybody with an interest getting to grips with. And, it should be no surprise that the legislation that governs legal services regulation the very first statutory objective in that legislation is protecting and promoting the public interest. And that's something that we need to be asking ourselves, what do we mean by that? And as is usually the case with complex questions like this, there are likely to be a series of trade-offs and tipping points. And I'm going to go through a few just to hopefully promote some conversation. So at what point does vigorous promotion of a client's interests tip over into bullying and intimidation that might in fact prevent a fair outcome? What about litigation strategies that are intended to silence, that exploit power imbalances or promote private ordering over the public interest? Is there any line to be drawn in terms of a lawyer's choice of client, or indeed his or her freedom to choose a client? And similarly, is the right to representation universal, applying equally to the defence and initiation of proceedings? And to what extent do we accept that right to be limited by resources? And indeed, for that question of resources to be in the hands of service providers. And finally, and it's not the end of an exhaustive list, but it's the end of my list, how much value do we place on the global perception of England and Wales, accepting present company, but our scheme applies to England and Wales, as a jurisdiction of integrity? And what does that mean for the efforts we expect of the legal sector to keep bad or dirty money out? And in my view, the view of my board, that these and other questions need to be at the centre of a public debate about what society expects of the legal professions that serve it. And that debate needs to involve everybody in this room and interests such as representative bodies, regulators, civil society groups, government, and many others, but above all, the public itself. I'll leave my remarks there.
Thank you, Matthew. You've raised a broader bag of issues that necessarily...
But I think you can trace a lot of the things we're talking about today down to that idea of what does it mean to be an ethically founded profession.
Yes. Might also be worth reflecting that the public interest was not in the first draft of the Legal Services Act.
Someone wise put it in. Was it you, Steve?
On that occasion, not. David, can I come to you? For the Law Society of England and Wales, as we clearly need to distinguish, but we've heard from the regulators. Yeah. Obviously, practitioners have to operate within a world of regulation, but also broader public and client expectation. So how are Law Society members experiencing this focus?
I think, I'm first off, I'm going to say really welcome Juliet and Matthew's comments. It is about leadership, it is about culture. I think some of the questions we might have and pose back to regulators is actually, do you have empathy? Do you understand some of the leadership and cultural challenges that many of our members face? So money laundering is a very interesting one. It evolves like the coronavirus. It's a constant chasing of a practice. Talk about AI, but the AI is enabling this in a really dangerous way, and the only answer is AI. But I think, we've seen the city firms in particular squeeze out quite a lot of money laundering. We're seeing the emergence of risk in other parts of the profession which are relatively, they're not babes in the wood, but they're not necessarily they don't have sophisticated compliance functions, don't have sophisticated business acceptance functions, and often, often they are as much victims in this as anything else, and it might not, and it may well be to do with their culture, it may well be to do with their leadership. And I think one of the things which is going to have to be a constant iteration between the representative bodies and the regulators, as all of this emerges, is actually, what represents real risk? Where is there evidence of where we need to intervene? Where are the points of lack of leadership? And we're very pleased that the SRA is publishing a lot of this, and I think we look forward to seeing what comes out next week, because everything points to what our members can do better, and that is great. I think for us, the question is pulling back and asking a bit about proportionality, about evidence of risk, and about focus. And that inevitably will change because things will always be changing. And I think that what I think is kind of quite good about this discussion is actually that that it's not couched in the kind of monstering is that there's all these terrible people out there in suits called solicitors, and and they need to be policed within an inch of their lives. It is actually about helping them to find their right way through these very difficult, challenging issues that they face. I think Matthew's point about quoting Lubna is really important. There are some baseline principles here, and I'll start with the magistrates' court. Right, every magistrates' court, every day it sits, is full of people you wouldn't want to live next door to. Right, every police station custody suite is full of people that are a horrible mess, and that will steal from you if given half the chance, because they're drug addicts and they've got problems in chaotic lives. Justice isn't a popularity contest. If you start saying that there are some clients you can't work for because they represent bad public interest, they represent bad people, they are bad, they're not the type of people we want to encourage in society, you mean the drug addict at the magistrates' court and in the police station custody suite. And it applies right up to the petrochemical company that's seeking legal advice on applying for North Sea oil extraction or gas extraction license. And the public interest is served, particularly around compliance, by making sure that the sort of least popular and the least socially valuable clients are given the best advice on how they can stick to the law. Right? It is a weird paradox and a counterintuitive element of this. So you don't want to stop advising and representing clients who might be socially unpopular. They, in many respects, are the people that need the advice and the compliance support most. So you need to understand that within that context. But there are some really, really challenging questions. I think Matthew was referring to SLAPs. There is no doubt that there has been a problem with strategic litigation against public participation. It's not a large-scale problem in our jurisdiction, but it is a problem. And it's a complicated problem to fix. And it is a process where lawyers are instructed not to achieve a legal remedy, simply to use process as a way of battering a client, a defendant into submission. We have seen it. It is real. And there is required reform. I think this needs to be carefully done. I think that we have some concerns that the government didn't want to do it. They're forced into it by their backbenchers. But this rather rapid introduction of anti-SLAPS legislation in the economic crime bill is kind of a bit unhelpful, because actually it leaves a big gap in what's not covered. It's not been terribly well drafted, and it hasn't really resolved Article 8 and Article 10 conflict under the Human Rights Act. It's a bit of a mess, and it is piecemeal legislation. I, for my sins, am on the SLAPS task force led by the DCMS, and our first meeting was addressed by the Secretary of State for Culture. She came in for 2 minutes, had a photograph taken, and left. We're a bit worried about this world, and we'd like some. And this goes back to kind of regulatory consideration and risk. If you're going to do stuff, if you're going to stamp out these abuses, do it carefully. Do it on the basis of evidence. Work with our members. And as Matthew and my organisation, I understand, have been having a bit of a correspondence on something to do with Russian sanctions, the sanctions regime against English and Welsh solicitors advising on international sanctions law. The government accidentally criminalised a lawyer working in the city advising an EU client on EU sanctions law. They accidentally made it a criminal offence. We've had to rush in to try and fix all of this, and there's a very unsatisfactory sticking plaster solution with a licence, and we're hoping to then later this year address it through new statutory instruments. But it is evidence of, don't rush at these things, don't do it in an ill-considered and evidence-free way. Talk to the profession, work with them to understand what works and what doesn't. And there's a cultural thing that goes back to this. So the 60-odd super experts in London on international sanctions law don't like loopholes. They don't like complexity. They like simplicity, like a regime that it can be understood easily by their clients and complied with by their clients. Our culture is not about non-compliance or finding loopholes. There is no such thing as a loophole. It's just the law. And actually this understanding that there's I ask, and this mistake was not SRA or LSB. This was at a governmental level, but actually it's an evidence of ask our members, ask us how we can help, ask us will it work, ask us how is it implementable within a real business environment in a real world. And I think those are the pleas we would make.
Thank you. Exactly. Strikes me with an interesting contrast there between Lubna as president of the Law Society rightly raising the issue of virtues, but you've then got a government responding to political and social pressure and engaging in arguably virtue signalling through legislation that then goes wrong because it hasn't been thought through properly.
Yes.
And against a set of principles. So there are some very significant tensions and balancing acts in all of this, which
we're seeing it at the moment with the monitoring of solicitors in asylum and immigration cases. That it is a government which is seeking to create a category of client who is unacceptable, which is somebody who has arrived in this country through irregular means. The Illegal Migration Act strips them of enormous amounts of legal remedies. You have more rights under the British courts as an oligarch living in Moscow than you do as an asylum seeker on the BBC Stockholm. It's quite bad. And actually, lawyers are being monstered for simply representing the interests of their clients, because there's been a group of clients that the government has chosen to say are beyond the pale and beyond, the protection of our law. And that is another issue that we need to be careful. We need to be very cautious about what that public interest is. Suella Braverman thinks at the moment and argues at the moment that the public interest is served by stripping asylum seekers of their rights and their rights of appeal in the UK courts. We disagree. We need to be really careful about that question.
Yeah. Can I use that international element just to spring to Diane from the Law Society of Scotland? Clearly a different jurisdiction, different regulatory framework, at least for the time being. How does this world look from north of the border?
So some of it looks almost identical. We regulate in the same way, and we'll be producing our regulatory reports on anti-money laundering work and sanctions work later this month. The scale is quite different. We have a supervised population of about 686 practices, 20% in Glasgow, 15% in Edinburgh. The majority have between 1 to 12 partners, so kind of different scale probably. About 11% of those are high risk, we would rate as, in terms of the business they do, but 89% are inherently low or medium risk. So there's a lot of similarities, and the work is very similar, and the reporting frameworks and requirements are very similar. The questions that you're raising about the ethics and values and virtues of lawyers, the same. Real concerns for us about the derogatory language used about lawyers and the challenges to the independence of lawyers in the legal sector from the state, and the importance of maintaining that so that we can all do our important work. About just over 90% of the AML reporting things that we've done relate to conveyancing. And I think I just wanted to throw that in because we've talked about big city firms, but this relates to the evolution and the ways in which criminal activity changes and seeks new pathways. So we're very active in providing information and advice to our members, but also in regulating and inspecting our population to try to recognise this threat evolves and changes all the time. The thing I'd like to add finally is just remembering that lawyers are dealing with this threat at a time when they are also under immense pressure. And in members' meetings, one of the things that very small practices say to us is there's so much to comply with. How can we do this? It's not a not wanting to do it. It's a how can we do this effectively and proportionately to demonstrate that we are complying and have the values and virtues in place. There's loads in all of this. It's such important work. it looks very similar. But I think the things I would point out is just noticing that the reach gets into quite small practices in rural areas all over the place. It's everyone's problem. It might look different, but it's the same thing. And also recognising that we're asking lawyers to deal with some really challenging issues when they're also challenged themselves and trying to, in many cases, keep their heads above water in a practice. And that's the context in which we're all trying to do all of this work. Leadership is essential, the values and principles the same. And I think that conversation you talked about what are the values and virtues of a lawyer, really important, just as the question of what is a lawyer and how do we treasure that really special thing that the law and lawyers offer in a civic society.
Thank you. So, there's so much to unpack there, and we're nearly out of time. I think the big question for me is you've got these external influences that are looking at lawyers and legal practice almost as an homogenous group, and we know they're not. I mean, you talk about the makeup of the profession in Scotland, it's the same pretty much in England in terms of very few large firms, a large number of small firms, but a lot of people in the large firms and about the same number in the small firms. So that in that sense, there isn't a single profession doing the same thing. And when we're all tarred with the same brush, it all starts to get very uncomfortable. And indeed, increasingly, as I said in my opening session, a lot of the people who are providing legal services these days may not be lawyers, they may not be regulated, they may not be human, and they may not be in the jurisdiction. But we're all getting lumbered with the same perception of somehow we're enabling these venal people. And so there's a tension, I think, between what strategic choices can we make as businesses. There are certain sectors or types of clients we want to go for. That necessarily means we're not going to target other clients. But that doesn't necessarily translate into, therefore, we're making objectionable decisions about the people we won't act for. And that overlay of strategic versus principle, public interest, independent representation, all the rest, becomes really quite tense. So I'm going to finish, and we're getting the red signal here, so breathe, if we may. Any thought, I don't want answers, just thoughts about what it might mean to be a lawyer in the 21st century against all of these economic, social, political, regulatory pressures. I'll go in the same order.
I just think, just very briefly, the one thing for me, it's connecting, as you say, lawyers work in a diverse range of firms, diverse range of settings, diverse range areas of law, but actually in all of those settings, connecting the work that you do with that idea of the role of the lawyer in society, recognising the wider public interest with which legal work and the systems of justice engage, and the core obligations that brings, and having those discussions, bringing it to life for your teams, your staff, and the people who work in your businesses.
Thank you.
Well, so barristers already operate within a very clear framework of ethics that emphasises their primary duty to the court, not to the client. And I am sceptical about importing a public interest test because I think it is inimical to access to justice. Read the blog I published on our website 2 or 3 weeks ago.
Thank you. Matthew?
So, in the interest of brevity, being a lawyer is more than just a job. Lawyers help keep our civil society safe and secure. If the legal professions forget that, we're all screwed. I think there is an argument that suggests that forgetting has started and needs to be reversed.
Thank you.
Good. Yes, I think this is the point, that lawyers are officers of the court. They have a duty to justice. Justice is essential for the good running of business, large and small, in the city and in small towns and villages throughout the country, and internationally too. But it's also important for social justice. We forget that element about it at our peril, and that is a threat at the moment. And the future is, I think, hopefully the same, but the future will be more complicated, will be more cacophonous, and will be more subject to much more change, largely technology-driven, than we've seen ever before. And I think adaptability and I think flexibility is going to have to be the watchword of a profession if it wishes to maintain its honour. It needs to be more adaptable, more agile, more fleet of foot, and that includes both the representative and the regulatory side of our world.
Yeah, thank you, Diane.
Justice needs allies, and lawyers need allies too. I think we can't let the profession be subject to the attacks because it gets in the way of all those important things that we value about civic society.
So I'm not going to attempt to summarise this session, but it strikes me that Matthew hit on something that's important. When I detect that there is a core, a solid core of what we're all seeking here. Maybe what we've not yet hit on is how to articulate that publicly in a way that lands with all of the people who have or should have an interest in justice, in legal representation, and in what it means to be a lawyer. So that's the challenge I'm going to leave you all with from this session. Can I thank the panel very much indeed for their thoughts? I noticed no one has picked up on Matthew's suggestion that the SRA and the BSB might merge.
Matter of time.
Well, we'll see about that, Matt. But can we please thank the panel in the usual way?